revisiting the constitutional right to freedom of religion, the right to equality. Foremost, we welcome our dear principal, Dr. Anil Kumar sir, in his absence, who is all our activities to our session. Next, we will begin with Sir and Srinivasan Ramaswamy. We most heartily welcome you to our gathering. We welcome you, Ms. Sridevi, our caring and inspiring head of the department, for joining us in all our endeavors. We welcome all our senior faculty members, teachers, students, and all other well-wishers in and out from our college for supporting us and joining us. Next, let's invoke the auspices of the Almighty with the prayer by Bill Gavri from DC to English, Sri Changana College, Kanadi.
Good evening, everyone. It's a privilege to address everyone here today, and I must at the outset thank everyone, and in particular Professor Manu Prakash for taking...
Sorry, Srini sir, sorry. There's a prayer by Gauri. After that, you can begin, sir.
Oh, okay, I'm so sorry. Yeah.
No problem, sir.
നന്മയാകുന്ന കാന്തി കാണുവാൻ കണ്ണിനാകീണമേ നല്ല വാക്കിൻ്റെ ശീലു ചൊല്ലുവാൻ നാവിനാകേണമേ സ്നേഹമാകുന്ന ഗീതമോ എൻ്റെ കാതിനിണയാകണേ സത്യമെന്നുള്ള ക്ഷീണമോടെ ഞാൻ ശാന്തിയറിയണമേ ഭൂമിയമ്മയെന്നറിയുവാനുള്ള ബോധമുണ്ടാകണേ ജീവജാലങ്ങളാകെയും ജന്മബന്ധുവായിടണേ ജാതിഭേദങ്ങളിന്ത ശാപമോ ദൂരെ മറയണമേ ലോകമൊന്നെന്ന പാഠമെന്നു മനസ്സിലെഴുതേണമേ
Thank you, Gavri, for that beautiful prayer. A few words about our guest speaker today. Advocate SRINIVASAN Ramaswamy is an advocate on record before the Supreme Court of India. He specializes in commercial law and has acted for various multinational entities and public utilities in a wide range of litigation before the Supreme Court. He also has a keen interest on constitutional law. Advocate Srinivasan Ramaswamy is a graduate of WB National University of Judicial Sciences, Kolkata, and has remained in active practice since 2015. Sir, it is our great pleasure to have you here with us. And now, with much further ado, we most gladly invite you for the talk. Sir, please.
Thank you so much for the kind words and the beautiful introduction. Good evening, everyone. It's a privilege to address everyone here today. And I'm very thankful to everyone from SSC College, and in particular Professor Manu Prakash, for taking this initiative to hold this discussion today and for inviting me to be a part of this discussion. My topic for discussion this evening is one which concerns the citizens of a secular state at its absolute core level. in my discussion this evening, I would like to cover the broad extent of religious freedom under the Indian Constitution. And while doing that, I would also like to discuss the Constituent Assembly debates, the discussions which were held between the members of the Constituent Assembly while framing this right to freedom of religion. And I would also like to strike a balance between the right to practice religion and the right to equality under Article 14. While doing that, what also merits discussion is the power of judicial review. That is the power of courts to intervene in religious affairs and the power of the state to legislate on religion. In a secular state, if at all it is open for the legislative and the judicial wing of the state to intervene in religious affairs. Towards the very end, I would also like to shed some light on the Uniform Civil Code, especially in the background of secularism in India. Now, why do I say that the right to freedom of religion is the very core of secularism in a country like India? I say that because the right to freedom of religion is a right which has been bestowed upon the citizens by the founding fathers of our Constitution, despite envisioning that the Indian state shall remain completely and in all manners disconnected to religion. In other words, India was always envisioned to be a secular state in letter and in spirit. But what does our Constitution really say about the freedom of religion? Where exactly do we find this fundamental right in the Constitution? And what is the extent and nature of this right? Is it at all open for any wing of the state to draw the contours of this right, to redefine the boundaries? These are some of the questions that I seek to discuss today. I'll try and keep my discussion as concise as possible, since I'm acutely aware that not all of us here might be well versed with the finer legal aspects of the Constitution. So therefore, I would like to start on a very clean slate. The right to freely practice and profess a religion of one's choice is in the nature of a fundamental right. It's a justiciable right set out under Part 3 of the Constitution. Article 25 of our Constitution contemplates that all persons are equally entitled to the right to freely profess and practice and to propagate one's own religion. The extent and degree of this right is, however, not absolute. There are certain self-constrained restrictions in the Constitution itself, which place restrictions upon the exercise of this right. Those restrictions are there in Article 25 itself, such as the right to freedom. Exercise of this right. If the exercise of this right is contrary to public order, morality, or if it impinges upon the fundamental rights of others. One might therefore ask if this right to freedom of religion less important as compared to the other fundamental rights? Let's say the right to equality under Article 14, or the right to freedom of speech, or the right to life and personal liberty. Well, maybe that is how the framers of our constitution intended it to be. Maybe they intended this right to be a less important right, so to say. Now, what is this? What is it that this right comprises of? What did the founding fathers of our constitution envision when they added this vital right into our constitution? Why was this right at all necessary in a secular state like ours? To understand all this, one might have to dig a little deeper into history and understand the discussions that took place at the time of drafting of the Constitution and the debates of the Constituent Assembly. 17th October 1949. This was the day when the Constituent Assembly hotly debated the incorporation of secularism in the Indian Constitution. The discussions began when one Mr. H.V. Kamath moved an amendment to the preamble for inclusion of the phrase, "in the name of God." This was also supported by some like Pandit Govind Malviya, who said that it was not entirely anti-secular for the preamble to begin with expressions such as "in the name of God" or "by the grace of the Supreme Being." This was, however, met with strong opposition by a few sections of the Constituent Assembly. By one, Sri Rajendra Prasad, who later on went on to become the President of the Indian Republic. Sri Rajendra Prasad persuaded the House that inclusion of any reference to God, either in the preamble or anywhere in the Indian Constitution, went against the basic spirit of religious freedom. And to say that Constitution was given in the name of God would defeat the very secular fabric of the Constitution. Therefore, the net result was that H.V. Kamath's amendment to the preamble was defeated by a vote of 68 to 41. However, back then, when the Constitution was being hotly debated and discussed in the Constituent Assembly, there was never an effort to include the expression secularism in the preamble of the Indian Constitution or anywhere in the Indian Constitution, if at all. Because there was a broad consensus among the members of the Constituent Assembly on the necessity of establishing a secular state. There was an understanding of the history of India, which prior to that time was comprised mostly of princely states and had differing religious affiliations. Therefore, there was a broad consensus that secularism was indeed needed and India had to be a secular state. And there had to be an element of inclusivity woven into the Constitution. Having said that, what kind of secular state that India had chosen to be? Was a state secular when it was completely detached from all kinds of religion and it was completely atheistic in nature? Or was a state meant to be secular when it respected all religions equally? The first view of secularism drew a definite line of separation between religion and state. And the state had no business to do with religion. The Constitution, in a state of this nature, did not and could not have any reference to God. The second view, on the other hand, was the idea of secularism, where the state respected all religions equally and all religious rites and practices were sought to be protected in equal measure. It was this school of secularism that was sought to be adopted by the Constituent Assembly as a part of the Indian Constitution. This was also the spirit embodied in the First Amendment of the American Constitution, which contemplated that the Congress shall not make any law in respect of religion or prohibit the exercise of religion. So there India borrowed some learnings from the US Constitution as well. The whole idea was, therefore, how could a democratic state where the government was elected by the people, where the government was for the people, and where the government was of the people, represent a religious majority at the expense of the rights and liberties of the religious minority? Thus, since there was no doubt that India would happen to be a democratic republic upon independence, secularism was a natural consequence. There was no other option. As I just mentioned a few minutes ago, the Constitution as it was in 1950 had no express reference to secularism. It was implied, it was implicit and understood, until its express inclusion in the preamble in the year 1976 by way of the 42nd Amendment. Thus, while India was envisioned as a secular democratic republic, the framers did envision equal respect for all religions and the right to practice thereof. It was for this reason that there were two very important provisions which were put into the Constitution. Those are Articles 25 and 26, and on which a bulk of our discussion today will happen. Why was it so? Why was it that the Indian state decided to be a secular democratic republic which would not have a religion of its own, but at the same time grant this very important right to practice and profess any religion upon its citizens? Why was it that the Constitution did not delete all references to religion altogether? So this was an unusual situation, and a reading of the Constituent Assembly debates would probably throw some light into this. It appears that India at the time of independence, and as it is now, was a heterogeneous society comprising of people from various religions, communities, castes, creeds, subcastes. So therefore, to maintain unity and the sanctity of this new state, it was felt desirable to grant to every individual a right to practice and freely profess one's own religion. Sometime in April 1947, the Constituent Assembly determined the right to practice religion as a fundamental right. There were, however, various irreconcilable differences among members of the drafting committee and also among members of the subcommittee on fundamental rights on the scope and extent of this religion. And there were doubts among various members of the Constituent Assembly as to whether a broad interpretation of this right to religion would also include, naturally, in it the right to practice certain antisocial customs, such as the practice of parda, the practice of child marriage, the practice of polygamy, unequal laws of inheritance, or even casteism. Therefore, to balance this right to practice religion and the right to equality was this check placed on the right to practice religion. That is, this right was made subject to public order, morality, and the other provisions of fundamental rights. However, there is this very interesting question which assumes relevance, especially in today's times. Does this right to practice and profess one's religion also grant to us or to religious denominations the right to proselytize? Do Indians at all have the right to religion? Yes, the answer happens to be a straightforward yes. Do they have the right to invite others to their own religion? Well, the Constitution appears to say that there is this right, because there is also this right to profess and propagate one's own religion. But there are laws in various states which impose checks on propagation of religion. Is it therefore not paradoxical in a sense that the Constitution on one hand permits free propagation of religion, but at the same time there are state-based laws which impose various checks on the right to propagate religion? Thus, having seen the right to practice religion in this background, it also becomes important to examine the balance between this right and the right to equality under Article 14. So when we speak of this balance between conflicting rights in the very same part of the Constitution, I ask myself, how is this balance to be struck? And who strikes this balance? Is it the state in its executive capacity that strikes this balance? Is it the legislature that strikes this balance? Or is it the judicial wing of the state? Can the state wearing any of these three hats rationalize religion, faith, and belief so as to negate the freedom of practice according to one's own faiths and belief? Can this act of rationalization be left to an elected government? Or the other school of thought is, should there at all be any restraint on this fundamental right to practice religion? To analyze these two conflicting school of thoughts, one can possibly start with the view of Dr. B.R. Ambedkar, who made this remark in one of the debates of the Constituent Assembly. Ambedkar, who was well known as a champion of civil liberties, did not see religion as having this vast, expansive scope so as to prevent the state from encroaching upon it. According to Ambedkar, the idea of liberty and the idea of social reform had to take precedence over any other right, especially in a system which has historically been full of inequalities and discrimination, and where inequalities have all along been in conflict with civil liberties. Therefore, it was on Dr. B.R. Ambedkar's vehement insistence that this right to freedom of religion was made subject to other fundamental rights, Therefore, when we say that right to freedom of religion has to be balanced with the right to equality, I also wish to dwell upon a topic with which most of us would be very familiar. That is the much discussed case of Sabrimala. This was a case where the Supreme Court endeavored to strike a balance between the right to equality granted to women under Article 14 and 15 of the Constitution and the right of religious denominations to practice and propagate religious customs and matters under Articles 25 and 26. In Sabrimala, the Supreme Court grappled with the interplay of the right to religious freedom with other fundamental rights. There was a very conscious endeavor on the part of Supreme Court to balance the right to equality, dignity, and the non-discrimination of women aged 15 to 50 years who were barred from entering the Sabrimala temple. This balance had to be struck with the right of religious denominations to manage their own affairs under Article 26. Therefore, a question which many of us might ask, including me, whether the court could have at all entered this arena of a religious denomination, exercising its right to practice and propagate religion in the garb of protecting this right to equality. Thus, in the first round of litigation, it was a split verdict. There were 4 judges of the Supreme Court who held that the bar on women aged 15 to 50 years from entering the shrine was unconstitutional and was violative of the right to equality. There was, however, one dissenting opinion of Justice Indu Malhotra, where she stated that, of course, a balance needed to be struck between the principles of equality and non-discrimination on one hand, and the protection of the liberties of religious belief and faith under Articles 25 and 26. However, it had to be done harmoniously, in a manner that the religious beliefs and the right to practice such religious beliefs are not obliterated altogether, in a manner that this fundamental right is not rendered meaningless. What else is interesting here is that this right under Article 25 and 26 to practice one's religion is gender neutral. The right to worship and preach one's religion is non-discriminatory right, and it is equally available to all individuals irrespective of their gender. What does that therefore mean? Does it mean that women aged 15 to 50 years also have the right to practice religion, and this bar on their entry impinges not only on their right to equality but also on their right to practice religion? Does this right of equality under Article 14 conflicts with the right of worshippers of the shrine under Article 25? So therefore, who is to strike this balance between these two conflicting rights? Can the judicial wing of the state embark upon an inquiry as to whether this belief, which is hundreds and thousands of years old, is constitutionally valid? Can the courts lay down certain objective standards or tests of rationality on the basis of which one can say that certain religious practices are illegal and certain practices are legal? What are these objective standards? What are these tests of rationality? Can this power of judicial review of religious practices be undertaken by the court by superimposing a sense of morality or rationality with respect to the form of worship? Can the courts tell religious denominations or worshippers that a certain belief held by them is legal, or that certain beliefs are completely opposed to law and morality? Would doing so not negate the freedom to practice one's religion? Is it also within the domain of courts? Because in a secular society like India, the judiciary, which is also a wing of the state, is understood to be secular in nature. So today, is it within the domain of a secular court to lay down certain objective standards and say that certain beliefs are illegal, to put it simply? Therefore, to deal with such religious-based matters, what the courts have done is they have come up with this test called the essential religious practice test, where only such religious practices that are determined to be very essential to that religion or religious denomination are given constitutional protection. This test fundamentally is an objective standard which does not find any mention in the Constitution, which does not find any mention in any law. This essential religious practice standard is therefore constitutionally unprincipled and to some extent even without any basis, because it involves a secular court making judgments on religion. Now, let me also give an example of a very interesting case from 1986. It was called Bijoy Emanuel's case. Now, this was a case where certain students in a school refused to sing the national anthem. And on that ground, they were sought to be prosecuted. It was a defense on behalf of the students that they belonged to this sect called the Jehovah's Witness. And to sing the national anthem would mean that they would be undermining their own religious belief and to practice their own religious custom was a fundamental right guaranteed to them under the Constitution. So what is it that the Supreme Court held? The court held that to mean a practice, to call a practice an essential religious practice, the practice has to be genuinely and conscientiously be held by persons claiming such beliefs. The Constitution reaffirmed that this was a right protected and guaranteed to all individuals irrespective of their religion. And this was also reaffirmed by the Supreme Court in Bijoy Emanuel's case. The determination of what is a religious belief or practice is therefore a very delicate task. To answer this question is therefore not to come up with a judicial perception of the particular belief or the practice in question, which may or may not be consistent or meet with approval of the religious denomination. The essential religious practice, therefore, presents various pitfalls. First of all, it militates against the religious community's constitutionally guaranteed autonomy to decide its own essential religious practices. This test also fails to appreciate that religions and cultures, especially in a heterogeneous society like India, are diverse. And cases like Sabrimala may involve highly localized temple rituals. The question, however, still remains as to whether the practice of excluding women of a particular age is an essential religious practice that can be granted constitutional protection. Now, there is another important question. Who decides as to what is an essential religious practice? Is it the court that determines what is an essential religious practice? Is it the religious denomination itself that determines what is an essential religious practice? And how much is it possible for a court of law to determine what is an essential religious practice? These are some questions which are really not easy to answer, and the courts are still struggling to find an answer to these questions. Likewise, there is also the practice of excommunication, which is prevalent among the Dawoodi Bohra community of Shia Muslims. That is also a subject matter of intense debate. There is one school of thought which would say that this right to excommunicate of the spiritual head goes against a very basic notion of the right to equality and the right against untouchability under Article 18 of the Constitution. There is this other school of thought which rallies in favor of the spiritual head and his right to excommunicate under Article 25 and 26 of the Constitution. All of these issues came up once before the Supreme Court in 1962. However, now there is a larger bench of the Supreme Court, a bench of 9 judges which is seized of this issue. There are certain other contentious issues where this interplay between the state's right to regulate religion on the grounds of protection of other fundamental rights such as the right to equality and the right to practice religion come up. There are issues like hijab ban in the state of Karnataka and whether it was open for the state at all to have come up with that ban. There is also this issue of triple talaq, which has now since been settled by the Supreme Court, where the Supreme Court said that triple talaq is not part of the essential religious practice in Islam, and as such, triple talaq was held to be illegal. Would the court at all have done that? Well, one may say that there are various factual differences which each case present, and one cannot really compare triple talaq to hijab ban or to Sabrimala, because each case presents its own complexities. Well, all of these issues are now sub judice before a larger bench, as I just said a few minutes ago, where the remit of the court is to determine this interplay between the freedom of religion and the protection of the right to equality. The court there is also dealing with the issue as to the extent to which a constitutional court can inquire into an essential religious practice. This, therefore, brings us to a slightly different topic, which at the same time is the subject matter of intense debate and discussion over the last several decades since the Constitution came into being. That is the idea of having a uniform civil code in India. Sometime in March of the year 1947, the Constituent Assembly was debating the inclusion of a uniform civil code in the Indian Constitution. There were various proposals to have provisions in the Indian Constitution which would contemplate a uniform civil code for all religious communities. Dr. B.R. Ambedkar again contemplated that subjects of the Indian state, subjects of the newly formed Indian state, shall have full right to claim benefit of all laws and proceedings for the security of persons and property that are enjoyed by such persons shall be regardless of any religious custom or usage. He was therefore a major proponent of the Uniform Civil Code. However, towards the end of May in 1947, there was a broad consensus in the Subcommittee on Fundamental Rights that Uniform Civil Code shall not be a part of fundamental rights, but shall be relegated as a directive principle of state policy. Now, there was some vital opposition to this by Rajkumari Amrit Kaur, who said that Uniform Civil Code was very essential to social progress and for a society like India at that time, which had various practices which were completely at odds with the right to equality. Again, when one has a uniform civil code in a secular, democratic republic country like India, how does one protect the right to practice religion guaranteed by the very same constitution under Article 25? So on one hand, you have uniform civil code, and on the other hand, you have this fundamental right to practice religion. So there appears to be a very major conflict in having uniform civil code and the right to religion at the very same time. In fact, this was also an objection raised by Mehboob Ali Beg in one of his speeches before the Constituent Assembly. He said that a secular state did not necessarily mean that there must be a common law observed by its citizens in all matters, including matters of daily life, etc. And there could be a secular state which protected all religions and guaranteed equal rights to all religious beliefs, but at the same time did not have a single set of laws that was meant to govern all religions. Therefore, it appears that to strike a balance between the demand for having a uniform civil code and the staunch opposition by certain sections of the Constituent Assembly, a midway approach was taken, and uniform civil code was made a directive principle and not a justiciable fundamental right. So that now leads us to the question as to how Article 44 of the Constitution, which contemplates Uniform Civil Code as a directive principle of state policy, and which must act as guidelines for the state in its functioning, be reconciled with the freedom to practice religion. If today there were to be a uniform civil code, would it not be in conflict with the fundamental right of religion? Would it not be in conflict with the idea of secularism, which sought to protect all religions in a heterogeneous society like India? Therefore, one may tend to think that this encroachment into the sphere of religion by any institution of the state, whether it is the executive, the legislature, or even the judiciary, would tend to pose grave concerns and may also have the effect of undermining what the framers of the Indian Constitution intended. Having said that, all that is now the subject matter of discussion before a larger bench of the Supreme Court, which is hearing all these issues, including Sabrimala, the right of the spiritual head of the Daudipura community to excommunicate, and various other rights of minorities. One view is that if the judicial wing of the state were to be granted wide powers of regulating what is the essential practice of a religion, then that may have the effect of obliterating the right to practice religion altogether. At the same time, there is also a need to enforce the right to equality, because India as a society was ridden with various social practices such as untouchability, child marriage, the practice of parda, that were completely inconsistent with the equalitarian society that was envisioned by the constitutional framers. This is that fine balance which, in my humble opinion, that the courts must strike while deciding this issue. Now, in case there are any questions by the audience, I'll be very happy to take.
Sir, the presentation is over. Is the presentation over?
Yes. I was just waiting to take questions from the audience.
Okay. Akhil, are you there?
Yes, sir.
Srini, can I ask a question, please?
Yes, please.
Srini, interpretation of the laws by the judges, the constitutional judges, it is primarily meant on various facets of the law as presented by advocates like you.
Yes.
So it is okay. I'll just now. So it is primarily dependent on the argument that you put across in a coherent form, presenting with various facets and facts and things on ground. So, uh, will it be right to say if you have if you have a battery of good lawyers arguing very favorably on a particular subject, the court can get misled?
Well, the converse also holds true. Both parties in a matter of such importance will be led by a battery of lawyers. So therefore, there will be forceful arguments on both sides.
Pardon?
So it is for the court.
Yeah, there was some echo in my phone again. Can you say the thing again?
Yes. So what I was saying is that in a matter of such importance, in a matter having such wide ramifications, both parties will have their own battery of lawyers to canvass arguments on their behalf. So therefore, it is for the court to weigh the pros and cons and to strike a balance so as to render justice in accordance with law.
Yeah, I take the point primarily because you see, in a case like Shabrimala, which happened, the people who were representing for the people and for the women, the ladies, I mean, women rights and all. So both had their own arguments. I fully agree the neutral stance taken by the court is okay, but however, a person who stays in the land, who was got a complete historical perspective of the whole issue, would be in a better position to understand the whole thing and issue a judgment properly. Can a complete neutral person, without understanding the sentiments of the whole issue, deliver a proper judgment? I can understand. Yeah, if you are part of the whole thing, your decision may get colored. I would agree to that. However, the whole issue, if perceived properly, I think a judgment can be made, which doesn't influence or alienate a larger section of the society.
I think that is a very pertinent point, and that is something which I also was discussing a while ago. So India is a secular state, and the judiciary, being a wing of the state, is also expected to be secular. And while hearing a case like Shabrimala, there are various parties that are involved. There was this group of petitioners that was challenging this religious practice on behalf of women. Then there was this group of respondents, including the Devaswam board, who said that this practice was an age-old practice and is being professed for the last thousands of years. And therefore, this was an essential religious practice. So therefore, my whole point in the discussion was, who is in a better position to say what is the right religious practice and what is the basis for it? Surely the court is not the best person to say that the religious practice is legal. Surely the people challenging it are not the right people to say. It is only the religious denomination who, on the basis of various customs and past practices, can say that this is an essential religious practice. A secular institution like the court may not therefore be well equipped to pass a logical standard or to lay down a logical standard as to which religious practice is legal and which is not.
Thank you. Thank you.
So therefore, this question is still pending before the 9-judge bench of the Supreme Court, which is dealing with the Shabrimala case. That bench now has to examine as to what is the extent of judiciary into religious matters. and if at all, judiciary can encroach upon religious issues.
Okay. Thank you, Srini. Thanks.
Thank you.
Okay, if
Yeah,
more questions are welcome.
Srinivasan,
Namaste.
I'm really privileged that I could listen to what all you had to offer, and then whatever you had told made terrible sense. So I just had one small question that right to religion is one thing. Right to not to have religion is also a valid thing, right? So there was a time when in Kerala, Communist Party had actually worked regarding the right for people or the ladies to cover their breast.
Yes.
It was there, and then it was not guaranteed by the religion, but had to be enforced.
Yes.
So now when we come to when we think about a Muslim girl, wearing hijab is something which is actually now considered as a right. People
Yes.
fight for that right. People say that wearing hijab, right to wear hijab.
Yes.
But my question is, there are people in that Muslim community, there are girls in that Muslim community who does not want to wear the hijab.
Yes.
What is the constitutional remedy regarding those people who don't want to do that? Which organization or which group of people are actually standing with those people who don't want to do that?
Yes.
I feel that they are alienated and there is nobody who speaks for them.
Right.
They are stuck there because there is no political leverage, there is no vote bank, or there is nothing which actually supports those kind of people. They are born in Muslim religion and then they are stuck there.
That
So
again
what
is a yes.
right?
That again is a very pertinent question, and as you pointed out rightly yourself, this is a practical difficulty. But if I were to answer this question from a legal standpoint, I would say that the right to practice a religion also inheres in it the right to remain an atheist. That also inheres in it the right not to practice a religion, because it is a right and not an obligation. So therefore, a religious denomination cannot force upon certain individuals certain practices which such individuals do not intend upon practicing. That is a right which is of course protected by the state. So today, if a person decides that he or she does not want to practice a particular religious tenet, could be anything, could be wearing hijab, that right will be protected by the court under Article 25, not only under Article 25, in fact under Article 19(1)(a) also, because that is the right to have an expression. But yes, as you rightly pointed out yourself, this is a practical difficulty. In a society like India, there is very little that we have to protect and guarantee the rights of these kind of people.
Thanks a lot, Srinivasan.
Thank you. Do we have any other questions? Professor Manu, do we have any other questions?
So, yes, questions are welcome. If anyone wants to ask more questions, you are welcome. Please come forward. Sumangala ma'am, are you there? Akhil, please, if you have any questions, please ask.
Hi, sir. I don't have any questions, but if anyone else is there, I'm be glad to hear to it.
Manu sir, Manu TS sir, if you have any questions further, because I just left the meeting, I couldn't listen to what you said. If you have any further questions, please, you can ask. Make it a discussion. Nobody comes.
No, actually, I am really privileged that I was able to be a part of this discussion, and then whatever Srinivasan Ramaswamy proposed, I'm really happy that I was a part of it. My question I asked, and then I think that I got the relevant answer also for that. And it is something which is it is a perpetual thing. We cannot just give a one-line answer and then solve it. So this is something which is there. I wanted to discuss it here, and I'm happy that I got a forum for saying it. I'm really impressed by your knowledge about this entire topic, Srinivasan.
Thank you so much.
Yeah. Thanks, Manu, for calling me into this thing, and then this 1 hour was very worth kind of for me.
Okay, thank you, Manu sir. Thank you. I hope that several advocates are there in our session. I don't know why they are keeping silent. If you have any doubts or any disagreement, of course, welcome. You are welcome. Please come forward. And
I think I would like to add one thing regarding religion, that
Yes, please.
when we talk about religion, it is actually more of spirituality. So we cannot just confide religion in legal parlance or the way in which we can actually contain it. It is more based on spirituality. So it could be Christian method of living, or Muslim or Hindu or whatever it is. It is actually spiritual. So you cannot exactly say that you follow this religion and then you have to propagate it in such a way, or these are the things which you have to follow. So
you're right. It is a very subjective issue, in the sense that, according to you, it may be spiritual, but there might be a certain group which might be dogmatic. There might be a certain group which might have certain set of beliefs. So what the Constitution does is to protect all these beliefs. So therefore, the question which I posed at the very end was whether a secular body like a court can at all decide which beliefs are right and which beliefs are wrong. Can it do that?
Yeah, true. Because when it comes to the boundary of another person, your freedom finishes.
Absolutely.
So you cannot just say that I'm spiritual, but I can invade your territory. It is not possible.
That's right. You're absolutely right.
okay, there are Khairli ma'am. Are you there? Have you got any question? Or Rosemary Miss is there? There are my dear teachers, colleagues. They're very, I think they can, I hope that they have their own questions to ask you. Nobody responds.
Manasa, may I ask a question?
Yeah, definitely. Rahul sir, please come and ask. Okay, Rahul. Srini sir,
Hello, Srinivasan sir. It's been a privilege and pleasure to listen to your session. My name is Rahul Ramesh, and I'm a professor of commerce. But I also teach students in the first years regarding contract law and corporate law.
Wow.
My question regarding I actually have like 2 or 3 questions, but I'll start with the first one. The thing
Yes.
is, one thing that I have really been concerned about from the societal point of view during my childhood to the society, how the society is right now, is something regarding religious disharmony. So I've
Yes.
always been thinking about something like the main problem, the main reason why religions came into existence is because like people believed in a higher power, but they just interpreted it in different ways, and that's how I see religions. But
Yes.
what has happened is the very religions which was meant to unite mankind itself is actually like segregating them in the basis of gods and religions and everything. So there's one question that has already always lingered my mind, that in India, there are political parties which are based on religion. You know that. So, what is your take on religious-based political parties propagating religious disharmony? Because we have been hearing about a lot of religious-based riots, which is
That's right.
when in there have been many instances regarding like riots in several areas. For example, in Godhra, in Gujarat,
Yes.
in Mumbai
Yes.
during the independence, during the when we attained independence, and during the
That's
partition.
that's
So,
right.
what is your what is your opinion on should there be political parties on the basis of religion? Doesn't it actually even in the in name of religion, it is actually using the a mass of people's faith into like implementing a propaganda which is very personal.
Yes. So let me throw some light on the law on this. So India, as all of us know, is a secular republic. That is, there is equal respect for all religions, which is why no political party under law is expected to ask for votes on the basis of religion. No political party is expected to make statements or speeches or publish anything which can result in communal discord. We have, at least on paper, laws to ensure that this does not happen. We have provisions in the Indian Penal Code which say that you cannot make incendiary speeches. You cannot say or do anything which results in communal discord. There are provisions in the Representation of People's Act which prohibit political parties from asking for votes on the basis of religion. As I said, of course, all this is on paper. But how much of this can really be implemented in a country as big as in India? How much of this can be put to practice? That's a different question altogether. We are a country of almost 1.5 billion people. We have at least 300 political parties. At any given point, when an election happens in India, there are about 800 million voters. So, in practice, when a political speech is made in some nook and corner of the country, what legal machinery do we have to ensure that communal discord does not happen? Of course, we do have legal machinery, but to put it into practice, to enforce that legal mechanism is a different ballgame altogether. That is where India as a society is lacking today. We simply lack the wherewithal to enforce the laws which we already have. We have every provision that there can be to prevent communal discord. Yet, we see riots once every 2-3 years. There were riots in Delhi in 2022. There were riots in Bombay, as you rightly mentioned, right after independence. We have had these laws all along, but we have simply not been able to enforce them. That would be my simple answer.
Okay, sir. Thank you so much.
Thank you.
Hello. I think we have 10 more minutes for the discussion. Is there any question further? Then you can ask. Come forward and ask.
No, I just wanted to add something to what Rahul asked. Srinivasan has to respond it in a legal point of view, because that is his purpose, and that is why he is here. So, other than that, Rahul, what I feel is that this tendency to divide between ourselves, that is something which the nature has put into us. Humans, if they don't have the tendency to divide, then they may conquer the nature. So we have this tendency, innate tendency between us to divide between ourselves in the name of religion or country or race or creed or whatever it is. You should also think in a point of view that what happens if we all join hands together and then stand as a species? We may defy nature, right? So I don't think nature wants us to do that. That could be the reason that there is division between humans in every way. So let us accept it. That's all.
I think that has been very succinctly put, and of course that is a wonderful way to look at it.
Thank you, Srinivas.
Yes, I feel that many questions are still lingering in the minds of many participants here, but I think it's time to wind up the session. Otherwise, questions. A single question, a single question is allowed. There's time left for a single question. Somebody may please come.
Good evening, Manu.
Yes, you can, definitely.
When Manu called me, I was actually busy, like working mother, listening academician, so balancing my roles. Sorry, Srinivasan sir. Sir, my doubt is a little, a very simple one. Do we still use Indian Penal Code or Bharatiya Nyaya Samhita? Which one we follow? Like,
yes. As of today, we have this new law called Bharatiya Nyaya Samhita. So, but having said that, Bharatiya Nyaya Samhita has a lot of provisions which have been borrowed from the Indian Penal Code. So there's not a great deal of difference between the two of them.
So we still use both these.
No. We use only Bharatiya Nyaya Samhita. We don't use Indian Penal Code.
Okay.
Yes.
Okay. Thank you.
Thank you.
Akhil, so let us wind up the session. Now, Srinivasan sir, so thank you for your wonderful and enlightening session. And in that session, you actually brought out the core issue of the topic, and that is the balance between the right to the essential fundamental right and the right to religion. So you actually have struck a difference between the right to equality under Article 14 and 14 and the right to religion, which is mentioned in Articles 25 and 26 of the Constitution. So actually, you spoke from the viewpoint of a learned and very unprejudiced jurist. So normally, the common people, render our opinions from our own limited point of view, and we are not learned in law, but you spoke from the standpoint of a well-learned jurist. So here we come to see the core issue you presented in your topic, and that is the issue of striking a balance between the right to religion and the right to equality. So, so normally we are not confronting this issue when we enter into discussions like this. So you have brought to our notice this vital issue. I feel that is the core problem, the core issue of the today's discussion. The conflicting rights, or the conflict between right to religion and the right to equality. So how to strike a balance between these two? And you have been so wonderful, and we are so privileged and grateful to you, Srini sir, for making this presentation in a very ample, clear, precise manner, and which we find it very easy to understand your viewpoints well, because you presented in a very concise and clear language. So our students are so privileged to listen to you, and we in the future we will be expecting more talks from your side on this valid constitutional issues, because we need to be aware about the constitutional ethos, the many nuances in law, and we have to understand that certain issues are not easily solvable, or we cannot find a clear-cut answer, a clear-cut one-sided answer to this nuanced issues like this. So in that regard, you have been so successful in presenting the nuanced topic as it deserves. So we will be expecting more of your talks on the issues like this, based on Constitution, and we were so thankful to you, sir, for presenting to us the history of our constitutional debates, the debates that preceded in the Constituent Assembly, because many of our people are not aware about or conversant with these facts, which are very essential for us to for our knowledge. So we are very much thankful to you, sir. So, and now I will be Akhil.
Thank you, Professor Prakash, for your kind words. I'll be very happy to engage in future discussions as well, and I'm so grateful for inviting me here today.
So we are privileged and grateful to you, sir, and so it's our pleasure, and so I as a coordinator, I extend my thankfulness to all the participants who came from other departments and other outside the college. So because your presence make this function successful, so your presence actually gratifies our happiness. So Akhil, officially let us wind up the session. So Akhil, please.
Yes, sir.
Okay. So thank you
Srinivasan,
all.
sir, we are really blessed to have you with us, sir, because it was such a mind enriching and enlightening session. We're so glad to had you here. And also thank you for all the questions and comments from the audience, without which it would have been more beautiful. And since we are moving to the concluding session, I would like to invite Annabelle from second year BA English, Sri Shankara College, Kaladi, to deliver the vote of thanks.
Good evening, all. It's my great pleasure to be a part in this session and deliver the vote of thanks to this gathering. Now, representing the Department of English, I hereby extend our gratitude to our principal for the great support he renders. This session wouldn't have been possible without the constant support of our head of the department, Sridevi ma'am. Thank you, ma'am. Our reverend guest speaker, Advocate SRINIVASAN Ramaswamy. We are really thankful for you for accepting our invitation and blessing us with your enlightening words. Thank you, sir. And I also extend our love towards all the other participants, including the students, teachers, and other well-wishers who have joined us. We also thank Advocate Manu Prakash for coordinating this event to such a grand extent. Thank you, sir. Once again,